being labeled a criminal, I find it, objectionable as well.
Okay, I'm sorry if you find it objectionable. You are not labeled by me, you're labeled by the magistrate who convicted you.
No, the magistrate convicted me, but you are the one labeling me, Mr.
Okay, what do we call somebody who has been convicted in a criminal court?
So just hold on. You've asked him a question. He has given an answer, says he's not going to comment on that, and he further objected to to your reference. And I would like us to move, Advocate Mpofu, beyond that.
No, Chairperson, we're not moving an inch. We're not going to move.
Why? He's answered you. He's not necessarily going to give you a specific answer that you want. He's given his answer in terms of what he believes is correct.
I don't want any answer. I'm saying that he must tell the truth.
You're asking him questions. You can't say you don't want any answer.
I don't know.
You've been asking him questions here. So you can't just now come back and say you don't want any answer. Why have you been asking him questions?
I'm saying to you, because you're saying he is not going to give the answer that I want. There's no question that I want. He didn't swear to give questions that I want. He swore to speak the truth.
Yeah, you're not happy with the way he's answering.
Yes, I'm not happy.
Yeah, but that should not really be the problem of this inquiry, because he is answering, Advocate Mpofu.
It is the
he
problem.
Is responding to your questions.
Yes, I've said this before.
Responding is spending an hour on one issue.
Well, that's a different matter. Now you're raising a question of time, but you're saying he must not answer my question. You're not allowed to do that. He must answer my question. I'm here.
And he is doing that.
Yes, but answering a question, Chair, is not just moving lips. I'm saying he must answer my question. I've asked him a question, and I'm not going to move an inch until my question is answered.
You have repeatedly asked your questions. He has repeatedly answered your question.
Yeah. What was the answer?
I'm sitting here all the time.
What was the answer?
I'm not going to do that to you.
No, but
I want you to proceed, and because I have to deal with issues of relevance here and the repetitiveness of your questions that you're answering, which are responded to all the time. This witness since yesterday and today has been answering all questions. You might not like the answers.
Yes. So
but accept his answers.
Are you okay? Thank you, Chairperson. So you are ruling that my question is irrelevant. That's what you're saying.
Did you hear me saying that?
Yes, you just said questions of relevance. That's what you just said.
No, I'm saying the repetitiveness of your questions is unacceptable, because the directives are very clear in terms of how we need to do that, and you know those directives.
What do they say?
I'd like you to proceed, please.
Yes. Okay. Thank you. The directives are that I have a right to cross-examine you, sir. That's what I'm busy doing. Okay? And I'm going to do it. All right. I was saying, Mr. Samuel, sorry, before that you and I are lawyers. Apart from anything else, you've also sworn to speak the truth to this committee, and you've also committed to assist them. Okay? So don't worry, relax. There's no crisis, contrary to popular belief.
I'm not worried.
Don't worry. Yeah, okay, at least you're not worried. Neither am I. So we are cool. We're going to finish this. If it's going to take us long, it's going to take us long, Mr. Samuel. There's a person here whose job is on the line, whose career is on the line, reputation is on the line, whose dignity is on the line, because among others, you sent a document which was taken by a member of this parliament and used to sanitize a motion that was defective in the manner I described to you this morning. And let me tell you one thing for free. We're going to finish this cross-examination and we're going to deal with every topic, because as I explained to you, you are probably the most important witness, because you cover the otherwise you'll be kicked out, whatever happens. But anyway, so I was saying to you, what do we call a person who is convicted in the criminal court of a crime.
We call him or her a convicted person.
Yes, that's true. Do we also call him or her a convicted criminal?
That is your conclusion, Advocate Mpofu. It's not mine. I do not call a person like that.
No, not you. I'm just being all society. There are other 60 million of us. Do we also call that person a convicted criminal?
No, I do not.
Have you ever heard such a term? It's the first time you're hearing it today.
No, I've heard it, but it's not my term.
Yes, no, I understand. It's not a term you approve of.
Yes.
But you know you are convicted of crime. As an attorney of the High Court of South Africa, I'm sure you're aware of that. Correct?
I'm aware of that.
All right. Now, and the point I was really making was not so much this convicted criminal thing. It was that crime was committed in the course and scope of your duties as part of the public protector, or is it the public attacker?
The incident happened in the course and scope of my employment.
Yes. Like you're supposed to protect the public, right?
Correct.
And you have been convicted of attacking a member of the public, a customer of the public protector. Are we still together?
Yes, we are.
Okay. And you can count. You know how to count from 1 to 10.
Are you asking me whether I can count?
Yes.
Oh, yes. It sounded like a statement. Yes, I can count.
Yes. So you said that when you assaulted Mr. Siabe, it was 2011.
When Mr. Siabe attacked me in my office, it was in 2011 on the 14th of
Yes, but Mr. Siabe.
You're putting a conclusion. You're saying I said when I assaulted him. I denied that I assaulted him.
I know you deny.
Yes.
Okay, but according to the magistrate, according to the law, you assaulted him. So when you assaulted Mr. Siabe was 2011.
The incident between me and Mr. Siabe happened in 2011.
Yes. And in 2017, the senior public prosecutor revived it.
That is correct.
But you told us that it was revived 9 years later, yesterday, didn't you?
That was not my evidence.
You never mentioned 9 years.
I mentioned 9 years in relation to me being charged for the internal disciplinary hearing, not the court, magistrate's court action. That one happened in 2017. But for me to be charged internally amongst the charges that were leveled against me after I had lost my affidavit to the speaker, it happened 9 years later.
So it's even worse. So the charges were reinstated in 2017.
Correct, yes.
And you were charged in 2020.
In the criminal court, in the magistrate's court, I was charged in 2017 when the charges were reinstated.
Yes.
But in the internal disciplinary hearing in the office of the public protector, I was charged in 2020.
Correct. Yes. No, yes. We're together there. That's exactly what I'm saying. So the charges were reinstated in 2017, and in the public protector's office, you were charged in 2020.
Correct, yes.
Okay, so that's 3 years.
Yes, between the two, yes.
It's not 9 years.
No, it's not.
Thank you. Okay, now you can count. All right. So, what you are really suggesting, let's cut through the chase here. What you were suggesting was that the public protector was had participated in your being charged as a form of some contrived thing. That's what you are really wanted us. The 9 years was meant to convey that how can this happen? This happened in 2011, and 9 years later, I'm charged. That's really what you wanted to convey. Let's just be honest about that, correct? Or what did you want to convey about the 9 years?
That issue, the issue of me being charged after 9 years was relevant in the disciplinary hearing and in arbitration, which are now settled. My reference to the fact that I was charged after 9 years was in relation to the other charges that were leveled against me. Chief amongst them being the fact that I had written to the speaker to ask for an investigation. That was the context within which I was making reference to that. And that is the fact I was charged internally after 9 years.
Is that your final answer?
That's my final answer.
Okay, now can you answer my question? I'm saying to you that what you wanted the committee to believe was that your being charged was so outrageous in the conduct of the public protector because the incident had happened in 2011, omitting deliberately the fact that actually the incident had just been revived by the prosecution services 3 years before. So the real gap between the revival and the charging was 3 years, a third of the period that you wanted the committee to believe, if you are not being found out as you are being found out now.
Chair, the crux of my evidence around that issue is this. Yes, I'm making the point that in charging me in 2020, 9 years after the incident happened, that conduct by the public protector was some kind of a revenge, in the sense that in 2020, I asked for an investigation into her conduct and how she's handling things in the office of the public protector.
All right.
So, no, I'm not done.
Okay, take your time.
So, and it is on that same basis that this charge was kicked out in the arbitration, because it did not happen in 2017. It happened in 2019. That is when it starts being counted to have been, whether it was reasonable or not. The employer, being the office, was aware of this incident, because they came to know about it on the same day when I reported it to the CEO.
Yeah.
So the delay was in charging me about that. That was what was found to be outrageously long.
Okay.
Yeah, so if you make it, if you want to confine it to the day that I was found guilty in 2017, that is not the date that this incident started. And the issue here is, when did the incident occur?
That's the issue for you. I'm saying, Mr. Samuel, but the reason you mentioned that, you just said something now. Let's just tie that down. So you're saying that the employer was presumed to know that the thing started in 2011 because the records are there, obviously.
Not presumed, the employer knew from 2011.
Yes.